On this episode of Law Weekly, we discuss issues of reforms in the judiciary, the role of lawyers, the bar, and even the bench. My guest is a senior advocate of Nigeria, Abiodun Olaleru. Also showing on the program, the Lagos State Ministry of Justice hosts a two-day strategic stakeholders meeting, discusses collaborative paths for effective justice delivery in the state. Plus a recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. My guest, Senior Advocate of Nigeria, Abiodun Olaleru, was called to the bar in 1993. He runs a mid-tier law firm that specializes in general civil litigation, admiralty, maritime, contracts, government liaison work, to mention a few. Last year, he was conferred with the prestigious rank of Senior Advocate of Nigeria. I began our interview with his assessment of the judiciary so far.
I will say that the judiciary has been able to contribute its fair share to the development of the country in terms of access to justice and in terms of the resolution of disputes, which is a key ingredient of our index of development, which is important for both foreign and local investors, because dispute resolution is very key to businesses and can be an entrance to investment. So I would say that the judiciary has been able to prove its mettle. The recent introduction of the new Supreme Court rules is also a case in point where you will see that the judiciary is doing its best to live up to the realities of the times that we live in terms of dispute resolution and access to justice.
Talking about dispute resolution, there's some uncertainty because most people know when they file a case, but they don't know when. They're not aware of when the cases will terminate and they will exit the justice system. What, in your opinion, are some of the factors responsible for the delay that we see with our cases in court, and what reforms do you think that we can introduce?
Going first to what is responsible for the delays, there are several factors. And I would say that it starts with the lawyers, in the sense that our people, when I say our people, Nigerians, are particularly litigious people. So because of that penchant, that contributes a lot to the clog in the wheel of the judiciary. And so the lawyers, the litigants, well, lay a lot of blame on the doorstep of lawyers who fail to advise their clients when they do not have arguable cases before the court. Because if you're a lawyer worth your onions, you tend to be able to, on a scale, to evaluate the strengths and weaknesses of a case when it is first brought to you in chambers. And it is at that point that the decision should be made as to whether indeed it is a cause that is worth pursuing at all. But I would confess to you that this duty that is expected of lawyers tends to be observed in the breach more often than not, and so you find a lot of cases that have no business being in the courts, clogging the dockets, and thereby asphyxiating the more important matters that need the attention of the judiciary. So it is a real problem. In terms of reform, Again, I would say reform. It has to also start again from the lawyers. In the sense, and part of the reforms is what I just mentioned. By the time a case is brought to you and you do an evaluation and you determine that, even if it's a commercial transaction, by the time you review the documents and I think it is for you to advise the client as to what you think, like I said before, what the strengths and the weakness of his case is, so that you then look at an alternative dispute resolution mechanism, for example, in order to see that, the parties can maybe sort out their differences and have a handshake, and maybe in the future, having amicably settled, they might still be able to do business in the future.
Say the requirement for taking silk, like you recently did, contributes to the deluge of cases that we see in our courts. That you have to have certain number of cases, and so lawyers will file any case just so that they can meet those requirements.
There are two ways of looking at that. That is one way. The other way is also especially when you consider the Supreme Court. The other way of looking at it is to ask yourself whether it is all cases that should get to the Supreme Court, for example. The Supreme Court all over the world are policy courts. It is not every decision of a court of appeal, for example, that should go to the Supreme Court. And that's a major reason why that court is bogged down by too many cases in my view. And I will give you an example of I think this was at the valedictory of the retired Honorable Justice Amina Hauki, where she referenced the case of a goat, of somebody stealing a goat, came to the Supreme Court, and she had to ask Mellon had to ask the colleague, the learned justice beside her, what are we doing? What are we doing? What are we doing here? And I tell you that up till as I speak with you, those kind of sentiments are still there. Frivolous cases like that should not enjoy the right of appeal. That should not enjoy the right of appeal up to the Supreme Court as is there. So in this regard, there is clearly need for a constitutional amendment to ensure that it is not every and all cases that travel all the way to the Supreme Court. And in this way, maybe this is also a call to the executive arm of government, and for the executive arm of government, the legislature, and the president himself to take the opportunity to write his name in gold by making substantial electoral reforms. So that our elections are seen as more transparent, and it can be easier for the contending parties to accept the outcome of the elections. Because as you know, a year or two prior to elections and the year after the elections, the various courts, from the Federal High Court to the Court of Appeal to the Supreme Court itself, they do practically no other thing apart from election matters. As a result of which, all other things are put on hold. We just cannot continue like that. It's not. It's a recipe for disaster, and until we take deliberate effort to address all of these matters, we may continue to complain, and nothing will happen.
What specific reforms with regards to the elections do you think is key?
There have been a lot of complaints about whether the beavers are working as they should and all of that. We all had thought that that should be a game changer in the sense that the electoral commission will be able to be more transparent in the election process in terms of how many voters have been accredited at the polling units, and relative to what the number of votes are and all of that. But the word out there from all the complaints that we are receiving, especially the recent Edo elections, is that possibly there were votes in excess of the voters that are accredited at polling units. So it then becomes very worrisome how, in the face of the beavers machine, that should be possible. Although the jury is still out on that. I understand this is now subject of litigation as a PDP. I understand has filed a petition. So it remains to be seen what happens in that regard.
Talking about the speed of justice, Lagos State has come up with some bills that is sent to the State Houses of Assembly. One of them seeks to fast track the hearing of tenancy cases and make it last between 3 to 6 months, and then for civil cases between 18 to 24 months. Do you think that those are things that can work, and would you commend it to other states?
I'll say it's a step in the right direction. I believe the bill you're referencing is the Administration of Civil Justice law. So it's a step in the right direction, but beyond the law, you also again have to go back to the operators, the lawyers, the courts, the judges. No matter how inventive the law is, if the operators do not give the necessary support, there ultimately will still be problems. The judge who, for example, will not come to court until 11 a.m. is unlikely to be able to fulfill the mandate of the 6 months and the 18 months to 2 years, respectively, as the case may be. So a lot lies at the doorstep of the operators, of the people who are expected to make the intendment of that law come into fruition. And that does not stop with the courts alone. But a great percentage of the responsibility also belongs to the lawyers.
Let's round off with a kind of agenda setting for what the CJN, or substantive CJN, can do to make things work better. And with her body language and the kind of things that she's been saying lately, are you confident that she'll be able to drive the reforms that we need in the judiciary?
I have known the Honorable Justice, the Honorable Justice Kekere JCON, for quite some time now, since she was a judge of the High Court in Ikeja. And I know her to be a very tough cookie, if I may use that word. So I do not for any moment have any doubts as to our resolve, for our preparedness for the task ahead. The immediate past Chief Justice of Nigeria, especially with the rules of court which have been amended just shortly before Melody, Honorable Justice Kekere was sworn in, I would like to believe has set the agenda for Melody CJN. Maybe a way to take that further and be able to make specific reforms. will be in terms of advocacy for the constitutional amendment, which I referenced earlier. I'm talking about cases getting up to the Supreme Court, for example. I still wonder why governorship cases have to get all the way to the Supreme Court. I still continue to wonder really why. So maybe that's so the constitutional amendment, and maybe in terms of electoral reforms, that should also be something to consider.
Welcome back. The Lagos State Ministry of Justice has held a 2-day strategic stakeholders meeting to discuss and chart a collaborative path for effective justice delivery in the state. The event brought together key actors in the justice sector who emphasized the need for greater synergy, transparency, and cooperation among all stakeholders. Here's the report.
Thank you so much.
The focus of this stakeholders meeting, which is at the instance of the Attorney General of Lagos and the state's Ministry of Justice, includes developing a process to enhance coordination between law enforcement agencies, staff of the Ministry of Justice, judges and other lawyers, particularly in the area of prosecution of state offences, where security agencies are deemed to have the general fiat of the Attorney General.
Today's meeting is a product.
The Attorney General sets the tone for the meeting with these statistics.
As at July 2024, before proceeding on court's annual vacation, the total number of cases pending in different courts with the government is involved are over 6,000. Land dispute having 2,500 cases, physical planning over 300 cases, housing 240, land dispute related to environment 75. We have physical planning related about 500. Then of course chieftaincy matter, breach of contract about 50, employment and pension related cases, fundamental rights issues are involved. All these cases, government financial exposure is in the range of about 114.5 billion naira. If judgment is actually entered against the state government. But we know it's an estimation. The mere fact that you claim 1 billion does not mean court will grant it. But we must work on that parameter, that we must avoid the exposure to government.
The Deputy Governor of Lagos, Dr. Obafemi Hamzat, sought the collaboration of the stakeholders, particularly in the areas of managing the state lands and the physical planning laws.
When you say a land-owning family, what does that mean? What exactly does it mean? Should we not define it? How do we, in order to build the red line, we paid compensation of 9 billion without doing anything. We've not done anything. We've not bought anything, but just to move people away, we paid 9 billion. That's why most states cannot do it. It's not possible. So Lagos State is the only state in the world that has done something like that, like a rail on a balance sheet. Others, federal must be involved. UK, 14% London City. The rest is federal government. New York underground, the same thing. So how do we manage our lands? So if our Ministry of Justice, our lawyers, and our judges don't have this proper understanding that the future of our children is threatened when these cases come to court, then we are missing the point.
Your presence here today.
A retired justice of the Federal High Court, Justice Mojisola Olatoregun, who serves as the chairman of the state's Public Complaints and Anti-Corruption Commission, emphasized the need for public trust and integrity.
Significantly, we must address the importance of public trust in the criminal justice system. Without trust, no amount of coordination between agencies will suffice. The public perception of a system that protects the rich and powerful while making scapegoats of those who are not as economically viable portends a great danger to the integrity of our legal framework. Rebuilding this trust requires both transparency and accountability in how cases are handled from arrest to trial.
The Ministry of Justice remains committed to ensuring that rule of law is upheld in all aspects of governance, while ensuring that improving the administration of justice in Lagos State is a key focus in line with the King's Purse agenda. It is believed that by fostering collaborations, we aim to strengthen legal frameworks, improve service delivery, and generally reduce the liability against the state in all aspects of governance.
The consensus at the end of these discussions here is that the recommendations and suggestions thrown up here will be implemented for the greater good of the citizens.
And just before we go, here's a quick recap of some of the top stories we're tracking at the court.
We begin with the report that the Supreme Court has reserved judgment in the suit filed by 16 states challenging the constitutionality of the laws establishing the Economic and Financial Crimes Commission and 2 others. The court said the date will be communicated to the parties when the judgment is ready. At the resumed hearing of the case on Tuesday, October 22nd, Imo, Bauchi, and Osun states joined the suit as co-plaintiffs, while Anambra, Ebonyi, and Adamawa states announced their decisions to withdraw their suits. The trial suits were struck out accordingly by the court. From the Supreme Court, we move to Kano, where the High Court has granted the Kano State Independent Electoral Commission the authority to proceed with the local government elections scheduled for Saturday, October 26th, nullifying all attempts by political parties to stop the exercise. Justice Sanusi Maaji, who presided over the case, ruled that Kansiak is empowered by the Constitution to conduct, supervise, and oversee local government elections across the 44 local government areas in Kano State. The judge emphasized that any effort to obstruct the process will be deemed null and void. His ruling comes after a federal high court presided over by Justice Simon Amuobeda halted the council elections, citing the alleged illegal constitution of Kansiak. In the dramatic turn of events, the same Justice Amuobeda of the Federal High Court Kano has sacked all 44 chairmanship and councillorship candidates of the New Nigeria People's Party for Saturday's October 26 local government elections. The ruling was delivered on Friday, October 25th, following a case filed by Engineer Mohammed Babayo and a faction of the NNPP against the party's leadership. Justice Amuobeda ruled that the Kano State Independent Electoral Commission should accept a new list of candidates submitted by the faction led by the recognized state's chairman, Dalhatu Shehu Usman, in accordance with the party's constitution. Still in Kano, a state high court has scheduled November 20th for the hearing of all pending applications in the ongoing case of alleged bribery and misappropriation of public funds against the national chairman of the All Progressives Congress, Dr. Abdullahi Ganduje, and 7 others. Ganduje, his wife Hafsat Umar, Abubakar Bawura, Umar Abdullahi Umar, Jubrila Muhammad, and 3 corporate entities, Lamash Properties Limited, Safari Textiles Limited, and Lasage General Enterprise Limited, are facing an 8-count charge filed by the state government. At the proceedings of Wednesday, October 23rd, the court was scheduled to hear a preliminary objection from the 6th defendant, but some of the parties requested for an adjournment to allow time to review the filings. Justice Amina Adamu Aliyu emphasized the importance of proper service of documents and subsequently adjourned the case until November 20th for the hearing of all pending applications. From Kano, we move to Abuja, where the Economic and Financial Crimes Commission (EFCC) has sought for adjournment of hearing in its first charge against the immediate past governor of Kogi State, Yahaya Bello, and 2 others. Counsel to the Commission, Senior Advocate of Nigeria, Rotimi Oyedepo, said the court issued the public summons against Bello, directing that same be published. Oyedepo also said he expected Bello to be in court on November 14, making reference to the 30-day duration of the summons, and therefore sought for adjournments till November 14 for arraignment of the 3 defendants. The trial judge, Justice Marian Anini, refused an oral application for bail by the defendants and asked that the applications be made formal and in writing. She subsequently adjourned to 14th and 20th November for response of the first defendants to summons and/or arraignment. And we round off with the reports that the federal government has dropped all charges against an executive at Binance Holdings, Tigran Gambarayan, on health grounds. Gambarayan has been facing money laundering trial from detention since April. A counsel for the Economic and Financial Crimes Commission announced the withdrawal of the charges at the Federal High Court, Abuja, before Justice Emeka Wite. The counsel said Mr. Gambarayan, a United States citizen, was merely an employee of Binance, whose activities he was being persecuted for. Counsel to Gambarayan, Senior Advocate of Nigeria, Mark Mordi, agreed with the prosecution, saying that his client was not involved in the company's broader financial decisions.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Shiele. Thank you for watching and see you next week.